Welcome back, everyone, to our second panel of the morning. This panel is in my schedule here. I also want to be able to tell you the timing of all this. So our next panel is Lessons from Lawyers for Ministry in the Church, and this panel will run up until our lunch break at noon. We may take a few more minutes into that break if we need to, depending on how many questions there are. That'll be our plan anyway in terms of the timing. And then after we're done with the panel, Kim's going to have a brief announcement for us. So we're welcoming three panelists this morning, and I'm going to introduce each of the panelists in the order in which they'll make their presentations. So first is Patrick Wall. Patrick has 31 years experience investigating, researching, testifying, publishing, and assisting district attorneys, civil lawyers, and bankruptcy lawyers on clerical sexual assault cases against minors. Mr. Wall is a former Benedictine monk and priest from St. John's Abbey, having worked for 6 years in the Archdiocese of St. Paul in Minneapolis. Patrick joined Jeff Anderson Associates in 2012 after working at Manley and Stewart for a decade. Mr. Wall also serves as a subject matter expert on artificial intelligence and stem cell research projects. Patrick has had the privilege to listen to survivors from Alaska to Ireland and can think of no higher calling than child protection and healing. Patrick resides in Los Angeles, California, enjoying spending free time with his adult daughter, hiking, experiencing the Getty, and some occasional Johnny football. Our second presenter, John Paul Kimes, was ordained a priest for the Maronite Eparchy of Our Lady of Lebanon of Los Angeles in the year 2000. After completing a licentiate and doctorate in Eastern Canon Law, Father Kimes served in the discipline section of the Congregation for the Doctrine of the Faith for more than 10 years. He was involved directly with the Supreme Apostolic Tribunal of the Congregation, as well as the College for the Examination of Recourses established by Pope Francis in 2014. Father Kimes has published widely on the law of the Church regarding the sexual abuse of minors and currently teaches canon law at Notre Dame Law School. Our third panelist is Mary Glowacki, who has worked for the Diocese of Fort Wayne South Bend for nearly 30 years, most recently as Special Assistant to the Bishop for Pastoral Concerns. A most important part of her work has been her ministry to those who have been sexually abused as minors by Catholic priests, a work she began in 2004 as Victim Assistance Coordinator for the diocese. Mary has an MA in Pastoral Theology and is a spiritual director. She has worked for many years as an advocate for those often unseen and unheard in our churches. She is also active in our larger community, serving on several foundation boards committed to serving the poor. So please welcome our panelist, first Patrick Wall.
All right, thank you so very much for the invitation. I mean that very dearly, Kim. Speaking for those who have no voice, that is really my calling, and that's the role that, believe it or not, civil law has come to fulfill. And in looking at all of the lessons I've learned, it's about the people. So I speak for Rachel from Alaska, for Linda from Delaware, for many, many folks you will never know of or ever hear of. But believe me, they are hurting, and they have been hurting all of their life. So some just general lessons I want to get to right to the point so you know where we're going. We're going to have some dissonance, right, between the civil system and the canonical system, and JP has volunteered to be that counterweight. So we're going to have two different pieces of music playing at the same time, and then Mary is going to harmonize all of this and how, seriously, these are lessons, right? How do we harmonize these two systems that simply do not see eye to eye? We really want you to have some lessons to be able to take to the parish and to work from the bottom up, okay? First and foremost, do no further harm. That has to be the mandate when you're listening to survivors. You must begin with survivors and automatically begin with the premise, do no further harm. So sometimes the best action is no action. The second that you have to know is that the body keeps the score. So that child has been criminally violated and the body has not forgotten, right down to the cellular level that they carry even to the moment of death. Third is you have to know what your ecclesiology is. If you do not know what your ecclesiology is when you sit down with a survivor, you have already gone off the path. The train is coming off the rails for sure, in my experience. The fourth thing is I really want you to be new Elijahs. I want you to believe that you can intervene and resurrect the dead. That you can take a person who is spiritually dead, psychologically dead, and in a lot of ways, completely emotionally across the board, a flatliner. And because of the small intervention that you do, even if it's for a 3-minute phone conversation, and you are the only person that they ever talk to about this secret, you can help them. And then lastly, the past will be the prologue to the future unless we choose a different way. And anyone who's heard me speak in the last 30 years, I'm sorry, that's the bottom line for me. And I know part of it's my Benedictine training, part of all the reading I've done, but we really, unless we choose a different path and a different premise to begin with, we will repeat the past. One observation right out of the gate is that panels need to have survivors on them. Panels must start with survivors. Panels must end with survivors. It has to be infused all the way through. A couple things I want you to think about. That's Phil Saviano from Boston. You probably saw him in the movie, yeah? And we believe them. We believe them because they persevered. We believe them because there's been 40 years of litigation and millions of documents to prove it. We believe them because they have survived the civil justice system. They have survived the criminal justice system. They have survived the bankruptcy system. They have almost run the complete gamut. It's not complete, but they've almost run the complete gamut of what's available on the civil side. And then lastly, you just have to know that, whenever you get to the level of 7,500 perpetrators, there's no mistake. This was not a oops. I want to answer the question right out of the gate because this is where your credibility comes into play immediately. When you're talking with a survivor, if you do not believe that leadership knew, you're in trouble in dealing with a survivor of childhood sexual assault. They absolutely knew. The documents are clear, back and forth, and the words are powerful in what Father Fitzgerald was telling the Holy See, but I also think presence is everything, because you know what happens in private conversations, right? That's when the truth truly comes forward. So there's Paul VI with Father Fitzgerald, the servants of the Paraclete, if you do not recognize him on the right side in the gray habit. Also, you should recognize that there was a religious order, a religious institute created specifically to help fallen priests. Systematic-wise, you have to say there's some knowledge there. Some lessons. I mean, this is about learning, right? So if we learn, we acknowledge what's real, but also you have to know what survivors already know in order to build that credibility gap when you're talking with them. I'm just going to tell you what they know. Powerful pieces are that this really started out with civil litigation, okay? And these are in the 1980s and 90s, and this was raw, hand-to-hand combat litigation where defense lawyers would take a survivor's deposition for up to 9 days against a perpetrator that they already knew was a perpetrator because they had a report back from the Paraclete saying that he was a sex offender. Okay, so those injustices did happen, but this is typical litigation. This is how all corporations and large institutions act. They always deny, and they always send in their army of defense lawyers to fight. That's just how it works. They used two specific things in primary defense in the earlier days. Number one is what I call the geographic solution, what others will call the geographic cure. They'll get the perpetrator out of the jurisdiction. They'll tell the authorities, we'll take care of it, and that it won't happen again. He'll never be in position of power over minors ever again. Well, that doesn't happen. They just get rotated around. And that's one of the things that has been proven in court over and over and over. The other thing was just the statute of limitations defense. Statute of limitations is simply a public policy saying that an institution should only be responsible for conduct up to a certain period of time. And that's an argument from economy, right? Businesses need to have certitude. They need to know that their liability ends somewhere. Insurance companies want that too, by the way. They need to know when their liability ends somewhere in order to be able to continue to function. I'm not saying that is a good moral position to take, but I'm saying that's what it was. And I tell you, that was effective, and leadership asserted the statute of limitations and knocked hundreds of survivors out of court. So the scandal continues. The problem didn't stop, and the hurting didn't stop. Next stage, civil windows started to happen, okay? And some people will refer to these as Lazarus cases. Well, they'll go in and they'll take the statute of limitations and say, we're gonna set it aside. This is what state legislatures can do. And they'll say for this period of time, cases that were previously barred by the statute of limitations, you can now bring them. And this happened in individual states periodically. California being one, Delaware being another, Minnesota being one. So it happened in disparate places. It happened at different times. It happened in Alaska. So all of these different places would happen, and then, well, it really wasn't, that terrible major. It didn't shake anything up in any real way. But one of the things that did happen is California changed its criminal statute of limitations. And at that point, and I was in Bill Hodgman's office and helping, we had 23 priests that were arrested in custody. We had dozens of more priests that were under investigation, and all of these criminal trials were starting to gear up and go. And then the Supreme Court ruled in the Stogner versus California case that it was unconstitutional to amend the criminal statute of limitations, which I believe was a correct interpretation, by the way, the ex post facto. Nobody wants the government or the Queen or any kind of person of authority to be able to go back and change the criminal law, because you know what people in power do. They change the criminal law to get rid of the people they want to get rid of. So this was a fantastic decision by the U.S. Supreme Court. However, it did shut down the scandal in Los Angeles, and Cardinal Mahoney did not go to jail. Judge Constance Sweeney should be a saint in the survivor community, because she's the one who forced Cardinal Law's deposition out in the open. When that happened, of course, the Holy See had to react, and they got him out of Dodge, one way. A couple things that happened in all of these settlements, though, Priest personnel files were starting to be produced. So the slow leak of information began. Next stage of the process was bankruptcy. Archbishop John Velazny was facing a civil trial in Portland in Oregon, and they were going to get run over. They knew it, and so their lawyers came to him and said, we do have an exit strategy. The federal bankruptcy code gives you the chance to get out of this. Because what it does, federal trumps state, and all litigation stopped. Every single civil case that was in the hopper came to a complete stop, and everything got sealed up. Very effective nuclear option, but they honestly didn't think about the fallout of this. Then San Diego happened. Another, there've been 31 bankruptcies now, but San Diego happened about 2005 or so, but they forgot that they probably should check out their assets first. And so the judge, she got really mad. Judge Adler got really mad, and she threatened to dismiss the bankruptcy. So they went, whoa, okay, and then a couple weeks later, they wrote the check and made it all go away. So again, the bottom line is here, in the bankruptcies are happening, but we're not really learning because, for instance, the Diocese of Fairbanks bankruptcy triggered the Jesuits of the former Oregon province, to have to also file for bankruptcy. Because more people were able to come forward, and all of a sudden, instead of having the 200 cases that they had in Alaska, they now had several hundred cases for the entire Northwest. And again, in the Milwaukee bankruptcy, documents came out, right? But the bankruptcy is effective because it shuts down litigation, it shuts down exposure, and it shuts down press coverage because the story's over. So again, scandal is averted. But we're still not learning here too much. The next stage that comes along is now all of a sudden we have this, oh my Lord, we never thought about grand jury reports. So again, things are continuing to build, right? We have the Pennsylvania grand jury report. Before Pennsylvania, this is from a civil lens standpoint now, before Pennsylvania, we only had, about 3,500 perpetrators that we knew about. That's when the fire alarm went out. If you want to avoid criminal possibility, if leadership wanted to avoid criminal possibility, then they had to get information out there to lower the pressure. And so all of a sudden now that's why we know about over 7,000 perpetrators. Because some people in leadership thought they had the potential to go to jail. All right? As we go through this, it really is criminal liability that leadership fears the most. It's not the scandal of children being hurt. It's not the loss of institutional money or anything like that. Because you got to remember, the institution in the 1980s was already preparing for this. That's why they were creating foundations. That's why they were creating trusts. That's why they created more options on how to try to work with perpetrators. That's why they developed the whole Diocesan Attorney Association. That's why they already had a very strong internal settlement program to be able to shut these cases down before they get to the public eye. So again, the goal that leadership wanted to reduce the scandal and keep it under control and out of the press was attained. So we didn't learn. So the lessons I really want to get to, and this is the whole meat and heart of it, is this is, I think, what has been learned. It was only when multiple states opened the statute of limitations and you had wars being fought on both coasts in gigantic states where hundreds and hundreds of cases were being brought, that the data got to such a critical level that the average person absolutely believed that it happened. Before this, survivors were not believed. Cardinal McCarrick was an extremely helpful story, as well as Marcel Massier from the Legionnaires of Christ, because these are guys that rose to the highest levels of leadership. On the Maciel case, and I worked on it for almost a dozen years, we were able to prove in court that the Holy See knew as early as 1958, based upon the complaints that were coming from various countries. So it was very well known, it was very well documented, and the canonical system was not allowed to function. The overall legal strategy, if I had to tell you what I think it is patient ambiguity. I believe that that is the strategy that they have adopted, they being the leadership. Obviously, I have a different ecclesiology. And the one thing, if I had a Nerf ball, every time someone says the church and they're not using precise language of what they mean the church is, we'd all be throwing Nerf balls at one another probably. But the whole idea is that we need to be extremely precise about what we mean by the church, okay? So we know that these numbers of perpetrators were out there. We know that religious orders had the same problem that the diocese had. We know that it was universal across the system. This is not an English-speaking problem. How many times have we heard that? It's not. It has nothing to do with language. It has nothing to do with your particular culture. It is in human nature. And just because I am ontologically changed does not mean I'm a human being, okay? The other thing that has been learned in litigation, and this is still coming out, is that, and this comes out in the Monsignor Carlo Alberto Capella case, right? And he was special assistant to the papal nuncio in Washington, D.C. The Monsignor allegedly downloaded child porn when he was visiting Detroit. He went over to Canada and downloaded it. And then he allegedly also downloaded it from the nunciature in Washington, D.C. And this came about because they got referrals from the Canadians and from the American State Department. That night, they put the Monsignor on a flight to Washington, D.C., and he's not returned to the United States. But the biggest lesson I want you to learn, and this is after all of my time with Oliver Francis O'Grady and being able to understand the mind of a perpetrator, is that there are three crimes that come together as the fruit of the poisonous tree. Is childhood sexual assault, the use of child imagery, both in the production, distribution of child imagery, criminal child imagery, which is, a lot what Facebook and all the other mega giants are arguing about right now. And the third one is the whole idea of transportation and exchanging children. That's what, if you really get into cases, that's what you find if you're able to investigate it to its fullest extent. The other thing is you cannot forget culture, what's happening around us, because this affects jury verdicts. Remember, in the American justice system, on the criminal side, we take away civil liberties to try to modify the behavior of the individual criminal. And on the civil side, we take away money damages in order to try to affect the actions of institutions. That's the ultimate thing. And believe me, when it gets to the civil justice system, that means something's already broken. Because basically this is like having a discussion with a whole bunch of ER doctors, right? This is because normal care medical care is completely broken down. So we cannot underestimate what we know about Prince Philip or Bill Cosby. Just take your pick, whichever one that you happen to have noticed in the news, right? The other thing that I want you to completely understand that's different, that most leadership don't get because of that internet thing, that people communicate across the world now. That there is the ability for attorneys in Australia to see the pattern in practice or to get notice I mean, in cases in LA, I've been able to get notice in Ireland and in England on those priests. And notice is an important thing because when you're proving up general negligence, you have to prove that they either knew or should have known. And the documents display it all. And the last thing is you need to know that is a severe, underestimated capability by leadership is artificial intelligence and machine learning, which are very different things, but it's the ability for us to take large amounts of data and to understand it, to melt it down into a nice discernible message, and to be able to show a jury pattern and practice. Even if they give us millions of documents now, in the past they used to overwhelm us and be able to overwhelm us. That's no longer the case. I need to move a little faster, but it's another piece of the puzzle here, and I hope this is a really good learning lesson that you can take to a parish is, first of all, do no further harm. Okay, well, that's nice. What does that mean? That means to offer to help families, not just survivors, because sometimes, you know, have you ever had this before where someone asks for a friend? This is kind of what it's like. If you really want to talk to a survivor, sometimes you have to talk to auntie or an Zio, or you need to talk to mom and dad or grandparents or a sibling, right? That's how you can actually have a direct conversation with the survivor. And to let survivors move on their own timeline, because they do. I'm sorry, they have a different internal clock. Most survivors don't come forward until they're as old as me in their mid-50s. And if survivors decline your offer of help, that is just fine. That's not the important thing. It's because you offered. That's what's important. Let them know that when they're ready, you'll be here. That is a lifeline. And I don't care if it's the civil system, the canonical system, the victims assistance coordinator, a local therapist, whomever. It can be an elder in the parish who is just the easiest going person. That person can be the lifeline. I want to give you a couple things too, specifically on in keeping the score. It's a difficult thing to understand, but if I had to melt it all down to this, and this is me stealing from the greats, right? I am giving homage to all kinds of people who have gone before me and have decades and spent their life trying to help survivors. Thomas Verner Moore, Gerald Fitzgerald, Leo Bartemeyer, Richard, Tom, Bessel Vanderkamp, Vince Folletti at Kaiser doing the ACE study down in San Diego. If I had to melt it all down, this is an important piece of the thesis here. Survivors experience trauma of criminal sexual assault at such a vulnerable point in their lives and in their development that the criminal conduct reverberates through every cell of their body in their shortened lives, because they do have shorter lifespans. They have greater amount of disease. You know, if you want, it's like a country western song. If you want to know what can go wrong, just talk to a couple thousand survivors and you will see everything that can go wrong in life. What matters is intervention. And I don't care what age the survivor is at. If you can intervene, the earlier the better, and the more often the better. Because people can, if given the opportunity, they can begin the healing process. But you have to focus on intervention. This is an important piece of the puzzle because I'll tell you straight up on litigation strategy, I try to figure out who I'm against and what their ecclesiology model is. I was one of those guys, I hated Richard McBrien, and I know I'm not supposed to say that here, okay? And I loved Avery Dulles in the Models of the Church because he got to the point, right? And this has always been a very helpful thing to me. I figure out what either the religious superior or the bishop or whoever the representative is on the other side, I figure out their ecclesiology and we exploit it. If they don't have a balanced ecclesiology, they're going to get run over eventually. So that's why I'm saying, know yourself. Know what your ecclesiology is. If you've forgotten and just went to sleep and everything has gone away, this is the heart of it. The legal process, in complete irony, provided solace to survivors. The legal process is cold, it's transactional, it's methodical, it has no feeling. Criminal law, civil law, especially bankruptcy, has no feeling at all. Zero empathy. I mean, there are times when I've taken clients in to do their police report, and I have to take the police officer outside and say, please take off your Kevlar. Please remove your service weapon. Please remove your secondary service weapon. Please open your collar. You don't have to have a tie on, right? I guarantee your safety. I will stop the client from hurting you, okay? But if you come in dressed like this, you're never going to find out anything because now you have just projected power. And what happened to them? They suffered abuse of power. So survivors have learned in the legal system, believe it or not, and some law firms are really good at it, some are horrendous. So it's completely uneven, right? But as a general rule, I've had great success because survivors, number one, feel they're believed. They feel they have a chance to tell somebody their deepest secret, and the public doesn't have to know about them. That they're not the only one because I can show it to them in the documents. That it wasn't their fault in any way, shape, or form. They have 0% culpability because the institution knew about it. And I have yet to find survivor number one in a case. There has always been notice in every single case. Even in Maciel. I mean, we got notice in 1958. Formal intervention. And the formal intervention can be as simple as you on the telephone talking to that person. Really helpful. And lastly, believe it or not, the legal system provides some kind of ceremonial closure. And those of you in liturgy probably see something parallel to other liturgical rites. And I need to shut up. A couple different responses that you can bring is to teach, to govern, to sanctify, to be ready, to have somebody ready. And as an old pastor, I know that running a parish, you basically you're hatching, matching, and dispatching, right? And so you're going to get them at those three stages of life as a general rule. And I propose to you that you make it known that you're willing to do a funeral rite that is open to survivors. It doesn't have to be in a church. As my dad used to say, we can have mass in a park. We can have a liturgy anywhere, right? And those of us from the Irish tradition knew that there were hundreds of years where we couldn't have an open liturgy because we were going to get killed, right? And so there are all kinds of ways to do this. Allow a survivor, give them options. Phil Silviano planned his own funeral. He even made his own little prayer cards. Remember how, in doing different things in these little memorials. So Phil was able to leave something concrete. It doesn't have to be big. It doesn't have to be momentous. We don't have to have diocesan approval. Just do your business. Run the parish like you know you need to run it. Help people and be ready. That's my message to you. And I just want to do some closing comments, and thank you for letting me run it over. The heart of the church is the people, right? It's the heartbeats, it's the soul, and the liturgy is everything. Because it's more about what we do then what we say, stop apologizing. A lot of survivors think it's hollow, so it's best just to start acting. And I just ask, is there something in the patristic tradition, the early church tradition, that we can pull together? Because this problem has been going on for millennia, and we need to look at our sources for wisdom. And most importantly, and I know you heard me say it multiple times, over and over and over, the bottom line lesson is this: make survivors your focus. That's the lesson from litigation. That's what the whole decades of litigation has taught us. If the survivor is the focus, it'll never get to litigation. It will be taken care of at the parish level. Thank you.
I will be neither as dramatic nor as long as Patrick. I'm glad that he was able to bring all of this information to the forefront. My presentation is going to be much more clinical because we have a lot of questions, I'm sure, so we're going to try to save a little bit of time for questions. What I'm going to try to show is the learning curve in the law of the church, particularly over the last 21 years. But in order to do that, I want to start back in the year 691. As one of the previous presenters talked about, in the Eastern tradition, this understanding of sin and evil, which comes into the tradition of the church in penal law. So there is an understanding of the church that sin finds its equivalent in the courtroom as crime. So there is necessarily within the law of the church a medicinal aspect to it, an approach to reconciliation, but not only is there an approach to reconciliation, but the key to this, so in Canon 102 of the Council in Trullo, we find advice for the distributor of justice, that the punishment must neither be so severe that it leads the person to despair and therefore loses his or her soul, but at the same time it cannot be so lenient that it leads them to believe that what they've done isn't wrong. So in finding the appropriate penalty, or penance, you can choose your model, in finding the appropriate penalty, this is the kind of balancing act that the church asks its ministers of justice to perform. Has this happened? Lord, no. But this is the internal dialogue that in distributing justice within the system of the church that the judge or the bishop must have. That I have souls in front of me. I have souls in front of me that can be lost because of despair. I have souls in front of me that can be lost because of leniency. I can't go too far in either direction because my concern is not just for justice in this earth, but for justice forever in eternity. So this is the equation, if you will. So Canon 102 of the Council in Trullo is the point of excellence in the legal tradition of the church where this medicinal aspect is laid out. So what can the law tell us? The law tells us a few things. It tells us that there's a responsibility in leadership in the church, first and foremost, and that responsibility is for the care of souls. It also tells us that the law is an instrument that should be an aid in the conversion of sinners. It should tell us that the law must focus and the leaders must focus on the harm that is caused by sin, not only to the sinner, but to the entire community. There should be a balance in punishment, again, and that balance in punishment should have in mind the goal of salvation. This is the framework, if you will, of the medicinal side of penal law in the church. So what has been learned over time? Again, just very, very quickly, very briefly, skipping the first 1900 years of the church, so not too much, just a little leap in time. So if we look at in the year 1917, this is the first time that the church publishes its one volume of law that is seen as universal in the church. Before then, you had these hundreds of thousands of documents that canon lawyers were supposed to peruse and know and all these sorts of things. So in 1917, we get a code. And in that code, Canon 2359 tells us that it is a crime for a cleric, so a priest, a deacon, or a bishop, remind the bishops, a priest, a deacon, or a bishop, to violate the sixth commandment of the Decalogue with a minor. A minor at that time was determined as someone who was under the age of 16. So the age of minor within the church was 16. This was a universal age for minor. So regarding marriage, regarding this crime, regarding whatever, a minor was 16. In 1994, the bishops in the United States of America, after some of their first experiences with the civil side of these cases, and I will say this publicly, Patrick and I may disagree on the interpretation of many facts, but we are very much in line that the church has learned a lot, but has a lot more to learn. So please, nothing that either one of us say is a criticism of the other or his interpretation of facts, but there are things that we're going to disagree about, but our goal is the same, to take what has been learned, to apply it, and then to learn more still from the victims. And that's what the church is very slowly beginning to do in her law. So in 1994, the bishops of the United States of America go to Rome and we have a problem. Houston, hello, a minor in the US is someone who's under the age of 18. A minor in canon law is someone who's under the age of 16. This is going to create an untenable tension between crimes that can be persecuted under civil law, but not be persecuted under church law. The church cannot adequately respond. So what does Rome do? It says, okay, fine. A minor for this crime is now raised to 18. This follows in 1996 in Ireland. So from 1994 in the US, a minor for this crime was, the age was 18. The other important thing that changes in 1994 is that statute of limitations that Patrick was speaking about. Now, in the church, the statute of limitations in canonical language is known as prescription. So when something is prescribed, that means that no criminal action can be taken. So it's the statute of limitations. It's the window between when an action happens and when it can be prosecuted. What Rome did in 1994, and this is, again, this is not a defense of the church's law. This is not a defense of anything. This is showing the learning curve. What Rome did is said, okay, 5 years is too little, clearly. 10 years is probably too little. So what we're going to do is we're going to say 10 years, but unlike any other criminal action in the church, those 10 years do not begin until the person reaches his or her 18th birthday. So whenever the abuse took place, that person, the victim, the survivor, has up to 10 years after their 18th birthday within which to present this claim within the church. So again, it's a tremendous step forward. Is it sufficient? No. But again, it shows a learning curve. We know that it is inconceivable that someone who is a victim survivor is going to report that abuse within 5 years. Oftentimes, it's impossible to report within 10 years. As Patrick said, it's much more the case that we find victim survivors reporting the abuse decades later. So the first step in the process for the church is changing the calculation of prescription and broadening that window. And then in 2001, these changes become universal. So in 1994, they become operative in the US. But in the year 2001, these changes become universal. So this is the promulgation of what's known as a motu proprio, so a legal form called Sacramentorum Sanctitatis Tutela, on April 29th, 2001. I can tell you, since I was a student of canon law in Rome on April 29th of 2001, this document made no blip on anyone's radar, period. And not only did it not make a blip on anyone's radar, if you go back, immediately it was seen that there were serious flaws in the law. And there are 4 changes, there are 4 modifications that are made within the first 18 months of the law being promulgated. And those 4 changes, primarily for your interests, are the ability to derogate from prescription. So what Patrick said about these look-back windows, we now have in the church, throw the window out the door. The window no longer needs to exist. There are conditions that cry out for justice that are so great, that have happened decades in the past, but those crimes are so horrific and the need for justice is so great, we don't care about the statute of limitations anymore. So if we need to, we can throw that out the window. From a legal perspective, this is more a nuclear option than bankruptcy. Bankruptcy on the civil side for the church was the nuclear option. Internally, this is a nuclear option. I mean, you have no idea how much as a lawyer, this just nothing about this is right, except for the need for justice. And that's why this happened. So prescription, the ability to throw prescription out the window comes in the year 2002. So just under a year after Sacramentum Sanctitatis Tutela is promulgated. The other thing that has changed immediately is that Article 17 of the law initially had this non nisi clause, so it could only be prosecuted by means of a judicial trial. Now, as slow as trials can be in civil justice in the church, a canon law penal trial was a four-headed unicorn with 3 leprechauns and a griffin riding on its back. Nobody knew what this beast looked like. So what the Pope did, or what, again, Ratzinger's insistence, Ratzinger goes back to JP2 and is like, look, this is not going to work. So we have 2 new options. One, an administrative process, which is a much leaner procedure to be used in the church, and the other is a second nuclear option, which is to present the material directly to the Pope for the Pope's direct action. So we've now, by the year 2003, we have two different nuclear options that have entered into the legislation of the church. So again, a learning curve. But what is learned now is we have age, we have the statute of limitation, and we have procedure. All of that is great. All of that is helpful. All of that is still insufficient. So in 2010, we have the first full-on revision of SST, but the guiding principle of the revision, as some of us that were present might remember, is that only those things that needed to be changed were going to be changed. This was not a wholesale revision. This was taking those things that had been learned through the 9 years of application of the law and trying to integrate them into this. So what do? We find our first movement toward a notion of another kind of vulnerability. The dirty secret is that by the law, in my humble opinion, was overspecified, because there are other categories of persons that the law naturally equates to a minor. By saying that this law was applicable only to minors under the age of 18, all of those other categories were set aside. And the only question that was being asked was, what is the age of the victim? This was an error born out of good intention. But it was, in my humble opinion, an error nonetheless. So in 2010, we get the first movement toward other kinds of vulnerability. What's that vulnerability? It's a new category of person in the law, those who habitually have an imperfect use of reason. So this was designed to protect other categories of people, but those with some sort of cognitive difficulty, cognitive deficiency, but something that was habitual. So this is not someone who got drunk one night and then got taken advantage of, or someone even who was drugged, unless, and then again, you have other kinds of law. We'll just skip over that. So we also have the new crime of child pornography. So child pornography at this time, the age is pinned at 14. Why 14, you ask? Because 14 was a legal category that was used prior in the law. It was again, another distinction of person that were younger than minors. It was a category of minors known as impuberes. So those who had not yet reached the age of puberty, which in the 1917 code was pegged at 14. This creates all kinds of problems that you can imagine with how do you determine the age, all of these sorts of questions get on. But again, pornography and a new kind of vulnerability. So in 2010, we get those advantages. Then we come to, again, we're making huge leaps in history now. We come to the prosecution of Cardinal McCarrick. And in the prosecution of Cardinal McCarrick, we learn a lot about different, even further categories of vulnerability that the church's law didn't have a place, didn't know what to do with. And we learn that, and through that and the prosecution of other bishops, and Patrick mentioned Monsignor Capello, who was in the diplomatic service of the Vatican, and I'm happy to close that circle just a little bit. At least in the canonical side, there was a prosecution and there was a definitive judgment, and it was very much not in Monsignor Capello's, or now former Monsignor Capello's favor. So former Monsignor, former Father Capello. So there has been a Vatican prosecution of that, which was part of, and again, Patrick knows this well, that was part of the deal of getting him out of the U.S., was that not only did the Vatican say he would have an ecclesiastical prosecution, but as a Vatican diplomat, he's a citizen of Vatican City State. the international body, so he was also subject to prosecution under the laws of the Vatican City State, which had been changed in 2013 to include the crime of child pornography 3 years after it became a crime in canon law. It was also a crime in Vatican State City law. So anyway, so after McCarrick, again, to sort of try to bring this train home, after McCarrick, we get the legislation Vos Estis Lux Mundi. I find it to be a terribly problematic piece of legislation for lots of different reasons. First of all, because it is a legislative mashup, and legislation doesn't smash up very well. Unlike, two popular songs, you can't make a smash of legislation and get a new hit. Title I is about new categories of vulnerability and the extension of the crime of sexual abuse of minors to the non-ordained, but only to those who are members of religious communities. So brothers and sisters are now, from May of 2019, are now prosecutable for this crime. The other really problematic part is the definition of vulnerable person. So you've taken the lessons of the McCarrick prosecution, which unfortunately is only months before this legislation comes out. So it's not like there's been a lot of time to process information and sit down and think about what we understand we need to protect vulnerable persons. Perfect. Who are they? How are they defined? Again, legally, this is setting aside moral questions, setting aside pastoral questions. Legally, how do you define a vulnerable person? With all due respect to the supreme legislator, if as a lawyer I were to apply this definition, which is the current definition of a vulnerable person, I could prosecute no one. Because there are very few human beings that at some point do not meet this definition. Which means that if everyone meets this definition, then legally no one meets this definition. I can't extend the law to everyone. It cannot be the case that every sexual act of a cleric who has made either perpetual vows or promises regarding living a chaste celibate life is a sin. Do all of those sins necessarily rise to the level of crime? And do all of those crimes necessarily rise to the level of what the church calls a more grave crime? That is, those crimes that are specifically reserved to the Congregation for the Doctrine of the Faith. The answer to all of those has to be no. Not every sexual act is going to be a crime. Not every sexual crime is going to be a more grave crime. So there's responsibility on the local level, there's responsibility on the international level at the Vatican, but there's also responsibility on the personal level of the priest, which goes back to all the questions from formation and all of those other things. How do we teach men to live chaste celibate lives in the 21st century? Legally, we have a change in language that, as a lawyer, drives me crazy because the crime in the church is a violation of the sixth commandment of the Decalogue. Vos Estis Lux Mundi uses the term sexual act. Sexual act, from a legal perspective, is very different than a violation of the sixth commandment of the Decalogue, because I can assure you that there are priests who have been prosecuted for sexting. Non-contact violations of the sixth commandment of the Decalogue are also criminal. A non-contact violation of the sixth commandment of the Decalogue is very difficult to define as a sexual act, in my humble opinion. So, again, movement forward, but imperfect movement. Let's call it that. And then there's just the general confusion between the parts 1 and parts 2 of the legislation that are less than perfect. In 2019, we have another step forward in support of victims and survivors. That is the ability to share information regarding their canonical processes. So the pontifical secret is lifted from all cases in which the sexual abuse of minors has taken place. This happens in 2019. There's lots more that can be said about all this. In 2020, we get another procedural step forward. So the CDF explaining the application of its own law, how the CDF works. Bishop, here's how you do your job. This is a public document, so even victims and survivors, if they want to know exactly how something is going to work, it's called a vademecum, which is Latin for idiot's guide to. So if you know nothing about canon law, you can open up the vademecum of the CDF and you too can figure out exactly what is supposed to happen. And it's written expressly that way. It's written as the idiot's guide to the application of law. Which then further extends, one might argue, I have been known to argue, to changes that are introduced into the penal code of the church in 2021. So Pope Francis completely revised the penal code. And in doing so, not only extended, so we already had the extension of the crime of sexual abuse of minors to members of institutes of religious life, so brothers and sisters. We now have that extension further to members of the faithful who, and again, legally, we have a little bit of a problem we have to work out. So who are these faithful who have a dignity or perform an office or a function or a ministry in the church? So again, a tremendous move forward so that the responsible parties are not just clerics, not only are they religious, but they're also lay people, and clearly the intention is those laity who have a public face, who are the public face of the church, whether it's a director of religious education, whether it's a CCD instructor, whether it's a pastoral minister, whatever. This is someone who is publicly recognized as acting on behalf of the church. Again, legally we have to work out the language, but we know what the intention is. We'll get there. And now we have a second revision of Sacramentorum Sanctitatis Tutela, and here we have a wholesale revision of the document. So we're in 2010, we only revised those parts we had to. 2021 is a complete rewriting of the text. And we have yet another addition that's added from the learning curve. So what's the easiest defense that someone can offer when it regards to sexual abuse of a minor? I didn't know how old he or she was. So, which creates ignorance, which creates the invalidity of an act within the law of the church, which creates the impossibility to impose a penalty if you can prove ignorance or error. So what did the CDF do? They said, okay, we're taking those off the table. Ignorance and error are no longer active defenses that could be used in regards to the sexual abuse of minors. So again, this is super technical legal language, but what it shows is the learning curve of the church. It shows that this learning curve is then being incorporated into her law so that when she faces these situations again, and here I'm using church in the broadest possible sense, but it's the broadest possible sense of the entire, the church around the world learning. And then making changes where the local bishop, the local religious superior, the local pastor, the local victims assistance coordinator, where everyone has access to that information. And where that information is written in a language that you don't have to pay people like me to come in and translate it for you. Not only is it available in various languages, it's written in a style that is approachable for people who are not specialists of the law. So we have tremendous movement forward in this sense. Pascite Gregem Dei is the apostolic letter that accompanies the changes of penal law in 2021. And Pope Francis describes penal law as a flexible means of correction and salvation capable of being applied swiftly and with pastoral charity in order to avoid more serious evils and to bring healing to injuries caused by human weakness. So why does the church have her own law? This is why. But it's up to us as practitioners of the law in applying the law to be sure that it is swift and that it does bring healing to injury caused by human weakness and that it does avoid more serious evil. Is there an inherent conflict between civil law and canon law in this point of view? And I'm going to close here and leave the rest of it for Mary. I apologize, too, for taking too long. There's just so much to share. And Patrick and I could probably stay up here for another 7 hours and answer questions and go back and forth. But the question now is, so here, is there an inherent conflict? Here's the inherent conflict that I found in teaching students of civil law. It's the perspective of the law of the church. For the law of the church, it is the entirety of the church that is damaged and harmed when one of these crimes takes place. In civil law, the focus is naturally on the individual. So we have inherently different points of view. It is, however, very clear to me as someone who has, been involved in the formulation of the church's law over the past 11 years, it's very clear to me that particularly in Pope Francis's latest change, that we have a turn that's taking place in the law of the church, so that it is no longer only focusing on the harm that is done to the entire community, which will always and necessarily be a concern for the application of law in the church, but it is taking a turn to include the focus on the individual, the specific harm that is done to an individual. And this is, in my opinion, this is where the law is going to change next. And this will require changes in procedural law. It will require other changes to be made in other parts of the law, but with the hope that it can be applied swiftly to not only bring justice, but also healing. Thank you.
Yes, seriously.
Is this on? Yeah, good, okay. Can you imagine being a victim survivor and all that? I mean, it's crazy kind of actually. I'm not a lawyer, and that'll become really evident even the more that I share. But I began my ministry in 2004 as a victim assistance coordinator. And my yes, although very well intentioned, was incredibly naive. I had no idea what I was saying yes to. And at the time, there were 2 victims in our diocese. And I thought, well, that was pretty manageable because I had other work, right? And it wasn't long, and I was consumed by those 2 situations, and you can imagine why, for lots of different reasons. In the years since, I didn't realize how this was going to impact me, and I certainly didn't realize how this was the situation. I don't even like calling it a crisis because it is so ongoing. It is so ongoing. It is truly part of us. We didn't realize how it was going to affect our church. Since then, I have attended, since 2004, many USCCB trainings, meetings, conferences, you name it, I've attended it, and trying to figure out how we can best serve, walk with people who are victim survivors. I have been blessed, and I am very aware of this, in my diocese, so I'm speaking just from our diocese. I want that to be very clear. But I am very blessed to work with a bishop who's never once denied me anything on behalf of a victim. And that could be a truck, it can be dentures, it can be counseling. We've had a victim who signed an appalling settlement 30 years ago, and I came to the bishop and said, this just isn't right. And we changed it. So I know it can happen. I know that it can happen. Even with that, with all that we try to do, we have found along the way that no matter what we've done, too many of our victims have been left without any sense of real justice across the board. It really didn't matter what we did or didn't do. There was this need for a stronger sense of justice, which when we talk about agency and empowerment, all the words that we've used these last days, they were looking for justice, and we weren't helping them find it, mostly because we didn't know how to do that. When I began my ministry, our review board was filled with lovely, dedicated, well-intentioned, church-loving people who were primarily lawyers. I remember vividly early on, I can say now that's not the case, but I remember early on walking into one of our review board meetings and overhearing this comment, well, our bleeding heart just showed up. Now, I don't think they meant it to be offensive, right? But it just showed the divide, because my perspective was this, it felt like there was this natural divide that is not, I can tell you I've seen it done really well and I've seen it done very badly, but it doesn't have to inherently, naturally be there. Early on, if someone even hinted at a lawsuit or even hinted at any kind of legal action, my care for them became extremely limited, and my relationship with the victim survivor became very strained, which I can tell you for me was really difficult. I can say now, again, in our diocese, that's not the case. When somebody says to me that they think they're going to want a settlement or they want to sue the diocese, I can simply say, we understand that that's an option for you, but what's important right now for you and for me is how I can care for you. That can be out there, but it does not preclude or exclude our care. We have a responsibility to work with that. In the National Catholic Register on May 9th, 2016, there was this statement: if churches are to be field hospitals, as Pope Francis so eloquently suggests, we should all understand who the patients really are and what they suffer. Can I tell you, victim survivors can be really hard. They break your heart. You can pour your whole self into them and think you're really making headway, and you do your very best for them, and you think it's good, and they call you up and say, I never want to hear from you again. Do not call me again. Do not speak to me again. It can be heartbreaking work, but it is beautiful work. It is beautiful work. We're left with lots of questions. When we saw that our victims weren't feeling that sense of justice or they weren't getting it, we had to ask ourselves some really, really hard questions. One of those is, what does it mean to truly know our victims, and how can we best help them heal? And I think early on in our conference, somebody said, several people have said, when you know a victim, you know one victim, right? You know one victim survivor. It's just one person. So learning that to know them, we had to meet them not just where they are, not just where they were, but we have to listen so intentionally. We have to listen to where do they want to go. We have to be able to hear their hopes and their dreams. I have seen the law done well, and I have seen it done very badly. What I've learned, that even with the law and our victim survivors and their families, that with care and honesty, we can bridge what can seem to be a very adversarial relationship between the pastoral concerns and responsibilities and the legal concerns and responsibilities. Simply by staying with what the victim is asking. If they lead asking for a settlement or for some kind of legal action, then we stay there. We can respond to that request with the same care and concern and love as if they had asked for counseling. It shouldn't make any difference. To hear and receive the pain of the financial devastation that many have experienced, it is so understandable why someone would want some kind of recompense, some kind of financial something, right? But we also know money does not heal. But how we respond when a victim survivor or their family asks for money, that certainly can be part of the healing. How do we speak about our victim survivors? What kind of language do we use? If you look at all the documents and if you look at our procedures in this diocese, sexual child abuse of a minor. Well, what's a minor? The people who come to me were abused as little boys and little girls. I've had to push back thinking about them actually all weekend, to be honest. Or they were girls and boys who were 16 or 17. And they were taken advantage of. They're not just minors, they're children. They're children. We have to choose our words so carefully, but we can choose them. And even in a legal process, we can explain a difficult legal process. We can get people to help us. And we do, we don't always agree. And I speak way more with our canon lawyers than civil lawyers. But if there's mutual respect and regard there, that will be extended to the victim survivor. When we can trust that the intention is the same to care, right? And I really believe that, then most often we can kind of figure out how we can do it. It's hard work, but it is incumbent on us to do the work. In the end, the truth sets us free. And so we have to ask ourselves, how can we be more transparent? We all say we need to be more transparent. Well, what does that look like? What does it mean to be more transparent? To tell the truth and to truly explain with patience and compassion with very complex civil and canonical issues. In our diocese, we used to, even in our settlements, the language would be alleged victim. 5 years ago, Bishop Rhodes changed that. It says victim survivor. They're not alleged. They're not alleged. And like Patrick was saying, we believe them. There are many people that we can't prove. We can't, can I tell you, I've never once received a false allegation in 18 years. I've received confused allegations. I've received troubled allegations. Nobody has come to falsely accuse any priest in our diocese. Believing in their goodness and believing in their sincerity, even if we can't prove what they're alleging, makes all the difference in how healing can happen. And I've had to say to people, I believe you, we can't prove it. And you know what? They all get it. They get it. The priest who abused them is dead. We have no way. But that does not mean that we can't care for them. It does not mean that we can't help them with financial concerns. It does not mean that we can't provide them counseling. Following the law, both canonical and civil, can and often does provide a sense of order, even though this was kind of disordered in the sense there was so much. It can provide an order and a context for someone to work on counseling over here, knowing that either a canonical or civil process is going on over here. We're working to help them get a truck, okay? It can all happen at the same time. It doesn't have to be separate or exclusive. Not following the law can re-victimize someone. What it does is it deepens the mistrust and the anxiety that is felt from first phone calls or first emails. I am humbled, and I still think this is wrong, but we're asking people who've been victimized by the church to call the church or email the church and then come to me, who works in the church, on the same floor as Bishop Rhodes, and tell me what's going on in your life, right? Doesn't make any sense. I don't know that I have a better way, to be honest. But by not following procedures and policies that are intended to protect our victim survivors, by not following the law, we just create greater mistrust. I hope our lawyers might have a comment about that, but following the law and being truly transparent about process can and does support healing in our larger community, not just with the victim survivors, but also in the universal church. Romans 13, 8 through 10 comes down to this. Therefore, love is the fulfillment of the law. And that's really and truly what this is about. I come to you today as a sister of someone who was sexually abused by a priest, as a victim assistance coordinator, and someone whose worldview has been changed and enriched by the faith of the people who come to me. They may not be part of this church, and we've said it along the way. I mean, I certainly can understand that. I certainly can understand that. But everyone has a story, and the legal part of this story is important because it's important for them to seek justice and to find justice. And often that can feel like it happens in a legal process. Again, even while we're doing everything else we should be doing. We have some very, very bad laws. I know more about canon law than I ever intended, right? But we can choose not to weaponize the law. We can choose that. I understand there are statutes of limitations, but there are no statute of limitations on compassion, on transparency, on integrity or honesty, being brave, helping someone seek justice, on doing the right thing. And I know that can sound really, really naive, and perhaps I am as naive now as I was in 2004, but I believe that. I really believe that. I'm leaving here from our conference convicted in that more than anything. It can be overwhelming. I wanna really end. There's a Franciscan priest, Richard Rohr. He says, pain that's not transformed will be transmitted. And so what this, pain that is not transformed will be transmitted, okay? And so that's what this is all about, right? And transformation is not gonna be in one moment, but we have to continue to work at it. I want to leave with just a quick story about one of our victim survivors. Her name was Carolyn, and actually there was a report about her here in the South Bend end of the diocese. And she was an incredible woman. She called me to tell me about her story. She was living in the Carolinas at that time. She wanted to meet with Bishop Rhodes, so we met with Bishop Rhodes, and her spiritual director was with her. When she came in, she had this file of 8 by 10 something. We didn't know what it was. We sat down, and I will tell you, Bishop Rhodes meets with everyone whenever they want it. So all our victim survivors are able to be with him. So we sat down, and Carolyn opened up this folder, and she started throwing these pictures of a little girl in a First Communion dress on the floor. And she looked at Bishop Rhodes, and she said, that little girl is dead. The next thing she said was she wanted a settlement. And Bishop Rhodes physically leaned into her, and he said, we can talk about that, Carolyn. We can talk about that. But tell me about you right now. Well, in the end, Carolyn did get a settlement. We had a great, relationship was amazing. And she was so helpful. She taught me so much. And she taught Bishop Rhodes. About 2 years after we met Caroline, she called me one day to say that she had pancreatic cancer. And I stayed in touch with her. And then she called me. She moved back here to South Bend to live with her daughter while she was in the last days of her life. And she called me and she said, Mary, I have one favor. She said, would you and Bishop Rhodes please meet me at the grotto and pray with me before I die? So one very sunny, warm day, we did meet at the grotto, and Bishop Rhodes prayed with her, and she died shortly thereafter. But Carolyn was such a witness to the wholeness. The settlement was part of it. It was an important part of it. How she was treated in the legal process, that was important. The prayer, the care, it's the whole. If I can't express anything else, it has to be the whole. Thank you.
Thank you to all of our panelists for those presentations. I didn't feel comfortable cutting anyone off, so we are 5 minutes past the start of the lunch hour. However, I think we can certainly take some time for questions, and I would just mention to maybe someone can get word to the Dawn at the front desk that we're running a little bit late. That would be helpful. So the floor is open for questions. As we said before, please speak into the microphone so that the people on the online group can hear your question. Okay.
Thank you very much to all of you. This was brilliant, and to everybody who's been presenting. It occurred to me as you all were speaking, and actually I think, Mary, you answered my question in a sense. How can we understand, and is it even applicable to think about, when we think about the church, the ecclesiology, do we have human rights in the church? I mean, is that a thing? I mean, we're hearing about, obviously, the rights of survivors in legal settings, but human rights are something altogether. They're part of, theologically, theological way to understand them is that they come with creation, being created in God's image. And what about that? I mean, John Paul II was such a champion of human rights, but maybe not in his own church. When I read some of his statements, very much promoting the whole human rights thing around the world, but in his own church, I mean, did he see the victims of Maciel, for instance, or whatever? So I just whatever ideas you have about that, I'd be curious.
Wow. So yes, and not in a flip way, but I two things. I think that the notion of human rights within the church is actually not the right way to not the right way to think about it. I think what we need to think about, going back to Patrick's insistence on ecclesiology and Mary's insistence that when you meet one victim and you know one victim, you know one victim. Setting aside the question of victimhood within the church, we are all members of one body. And I think a better way to think about the question of human rights in the church is to use Paul's understanding that the eye can't say to the ear, I don't need you. And that if we understand our relationships to one another because of Christ and in Christ, we go beyond any civil understanding of human rights questions. Now that's a high-minded idea, a very theologically minded answer from a canon lawyer, which you won't often find. But I think that the language of, I would say this, my criticism of the language of rights is the minute we talk about rights, we talk about vindicating them. And we over-legalize our baptism. Does the church have rights? Yes. Do we have rights as baptized members in the church? Absolutely. But if we think about it as rights, and our question is vindication, and we're going to vindicate the rights, then we're looking at legal structures. And I just think that's the wrong way to think about our responsibility to one another. And I'd rather think about our mutual responsibility as in a genuine Christian sense, that if we're in the body of Christ, we are one, and we have rights, we have responsibilities to one another more than I have rights that I can claim against you. I have responsibilities because of my relationship to you.
Not going to be surprised we don't see the world the same. The couple facts. Number one, that the Holy See has been requested in Geneva and has refused to respond now for 2 decades, where the UN, or not the UN, but the Geneva is asking for data on known child abusers in the church around the world, and they won't even answer the request. There's no enforcement mechanism, but as far as from a human rights discussion, Geneva is probably the forum to have that discussion. Second piece of it is we have attempted, because that's, you ask a surgeon, what should you do? Well, we've got surgical options, right? So you ask a bunch of lawyers, what do we have? We have legal options, right? And to trying to submit cases either in the criminal court or in Geneva, and we can't get any standing to be able to move forward because they simply do not respond. So patient ambiguity and waiting for the wave to fall over, that's another piece of evidence as far as their legal strategy goes. That would be an easy place to start the whole process. The institution has tremendous data from around the world, but also through the various treatment centers that we've had in the United States and in other places to know about the actual number of perpetrators, how the criminal mind works. But the thing I want to point out to you is the complete absence of data on survivors. And so there doesn't seem to be anything that's written down, and a good lawyer would tell you don't write it down, right? But but if you ask a vicar general about a particular perpetrator under oath, and you lay out a fact pattern, and you say, well, Father O'Grady did this, this, and this, and then they'll jerk back because it doesn't fit the pattern that they have known as the pattern and practice of that particular perpetrator. So there's a lot of data in the guys' heads. They know how to handle cases around the world, and that's what we're learning in France, right? And that's what we've learned in the Irish reports. We've learned in Australia. We've learned in New Zealand, and beginning now in Spain, very slowly, it sounds like.
Okay, not a legal brain, right? We have something better than rights. We have dignity. And no matter what your discipline is in the church, no matter who we are or what we do, if we continue to work to preserve that, to protect it, and to honor it, we will know the way to go. We will know how to, I don't know if we would say harmonize this, but we will know how to work with it. Not a legal answer by any means, right?
You anticipated my question, Patrick, in the sense of I'd like your commentary on the French report, because the French report's extremely controversial because of the projected or predicted numbers. But I think actually the French report is a gross underestimate of the number of victims in their country. One of the things that I'd like to see, or one of the aspects I'd like you to sort of talk about is, here in the United States, we now know 7,500 perpetrators, and now 35,000, I think, is estimated, close to, of known victims. And I think for us to get our heads around the fact that these are the people who have come forward that we know about. Now, how do we sort of grasp the data of the unknown? If we know, and the FBI is saying that 85 to 90% of sexual assault victims never come forward, what can we do and how can we project actual data, actual cases, as opposed to those that are just reported? And I say just in the sense of the larger sort of schemata of the actual numbers. And so maybe some sort of sense of data analysis, and where are we with that?
I can tell you where some data points are available, but they're disparate, so they're not brought together. Ken Feinberg and Camille Barros, remember they ran the BP oil spill settlement stuff? They have helped various dioceses across the country and settled hundreds and hundreds of cases. So there's a bunch of data available there. There's data, no one has really ever, one of the vicar generals I worked for, Kevin McDonough, no one's ever really debriefed Kevin as far as the actual amount that we know about in St. Paul, Minneapolis. Or, John Urell in Orange, or Tom Curry in Los Angeles. So there's a group of folks in the tribunal and in the chancery office who have all of this in their heads, that the data is alive, but you wait another decade or two, the data will be gone, okay? So that's one set of data. Another set of data is with all the insurance companies. Because remember, Holy Mother Church has its own insurers, but it also has commercial insurers as well. So there's data sitting there. There's data sitting in defense lawyers' offices. There's data sitting in plaintiff lawyers' offices. There's data sitting in the criminal courts that just never got off the ground. As Dale Bearclaw in Los Angeles will tell you that it never got to the point where he could get a DA to charge. Or you'll have all kinds of different disparate points, and it would take someone in leadership with extreme moral courage, because they're going to get their head chopped off, honestly, to call for this. And then, or even just the whole element of completing the process of the credibly accused reports. We have got, dozens and dozens of religious institutes that haven't reported. We've got major dioceses who haven't reported as well. So those data points could be extremely helpful. I can tell you because of testimony that a lot of the medical files of the various priest perpetrators have been destroyed from Seton in Baltimore or from the Paracletes in Jimenez Springs. And so that data is no longer available to us. Some of those medical reports are sitting in Chancery archives in the 489 files. So that's another data source that could be extremely helpful. But again, no good defense lawyer in the right mind is ever going to allow a bishop or religious superior to release that, because it gets you into negligence problems, right? So it's there. We're in a if you look at it, they're in a tough position. But if sometimes to do the right thing is extremely painful.
I would just add briefly, on some of the speculative aspects of the French report. That's data we'll never have in this country for the cops that were called in when father was caught red-handed, and it was the 1960s or 70s or even 80s, and this is father. We'll call the bishop, and the diocese will take care of it. There's no police report. So not only is there no DA charges, but there are no police reports, there's no whatever, plus the grave difficulty that many victim survivors have for bringing those claims forward. So I think that the best we can ever do is guesstimate, but we'll never have enough data to actually be able to sit down and say, here we know everything. We'll never have that data.
I just want to affirm again that this panel is worth its weight in gold. One thing that Mary had said was that we don't need to weaponize the law, especially in terms of the way that diocesan structures, ecclesial structures approach both civil and canonical cases. And I was wondering, it came to my mind that, one of the fundamental shifts that's happened for us is that we've moved from thinking about this in terms of institutional protection to prioritizing victims. What are some of the ways, Patrick, from the civil side, Father John Paul from the canonical side, that we can prioritize that even in the way that we approach cases on behalf of dioceses, other things like that? How can we prioritize just as a shift in standpoint mindset?
99% of cases never go to trial. That's just a kind of a general rule of thumb. And on priest rape and sodomy cases, very few have ever gone to trial. And when they do, of course, the jury settlements are just scare the eyeballs right out of your head, like as Rudy Koss in Texas, or Oliver O'Grady in Stockton, or whichever one you want to go at. I mean, even the more recent one in St. Paul with Father Fitzgerald, the OMI priest, and the jury came back for $8 million on one case alone, and then of course that rolled the Diocese of Duluth into bankruptcy. It was that case for me was horrendous, because Tom and Richard and I specifically wrote sex, priests, and secret codes because we got sick and tired of writing the same declaration over and over and over, right? And we even attached documents in the back as descriptors. Well, some of the documents in the back of the book that we published in, I think it was 04, 05, whenever it came out, the diocese refused to produce those documents, and they said they didn't exist. Trials are necessary when you have unreasonable parties. Okay, so we're going to need that. We're going to need that as an enforcement tool. But as we go forward, if the people of God told the leadership that it's no longer acceptable to spend millions and millions of dollars on thousands of lawyers and paralegals to defend the indefensible, and we need to come to some kind of harmonious end to help people, then then the process turns into a completely different adversarial position, because that's what civil law is. It's a straight up offense where we call black R, black L, and we knock the living hell out of them. And that's what the other side does to our survivors. And that's, so if you're going to go on the gridiron, that's what's going to happen, right? So I think the advice that I would give is, especially if you have well-known perpetrators, you've got the same pattern in practice, Why are we going to civil litigation? And then why are we being so stupid that we put ourselves in bankruptcy? It doesn't make any reasonable sense.
I'd just say practically there are procedures procedural law. There are aspects of procedural law that need to be changed. One of them I was talking about in class just the other day. A victim survivor in a canonical process is a witness. He or she is not a party in the process. This is a grave lack. It's not that they can't be, but in order to be, you have to use a certain kind of procedure, and then you have to sign on at the right time. And no one ever sits down with a victim survivor and says, along with your rights in civil law and along with the ability to proceed in civil law, that same possibility exists in the church. And here's what that would look like, and here is how that will go, and here's an advocate who will help you if you want to engage this process as more than a witness. And again, this goes back to that perspective of the law of the church, that it's the community that's been harmed. So being able to create a procedural mechanism that mandates, in a certain sense, the participation or the inclusion of a victim survivor as a participant in the trial, not just as a witness, that I think is a procedural change that could go a long way. Again, if the victim survivor wants that. But right now, even if he or she wanted to, it would take, it's outside of their grasp, unless they have an expert in canon law who's sitting by their side and says, okay, this is how you do it.
So we have one more question from the floor, but we're 22 minutes over.
And we had planned to go short to leave more time for questions. So just so you know that this was not intentional.
So it's come up several times through the course of the conference, the issue of adult survivors of sexual abuse and how difficult it has been for them to have any recourse legally. So I wanted to just ask, that Father John Paul talked about the law about, or the canon law about any adult who's doesn't have the ability to reason could do this. I mean, to me, that would be anybody who's in a power dynamic relationship, not just somebody who has cognitive deficits or things like that. And so I don't know where things are at with both in the canon law and in the civil system or legal system that can help people in this way. I think it would be nice to just hear a little bit about that.
If I may, I'll start and then let Patrick pick up, and Mary will probably need to get involved to sort of close the circle. What we see in the legislation Vos Estis Lux Mundi is an attempt to address that. But it's an attempt to address it that, in my humble opinion, is too fresh on the heels of McCarrick's case, in that it was clear that there was outrage in the part of the church, legitimate and well-founded outrage. Not just because McCarrick was a cardinal, and not just for all of those things, but the historic pattern of power-based abusive relationships. That's what it boils down to. And Vos Estis Lux Mundi, I know is an attempt to address that. I think it completely misses the mark. But what we have, and to the legislator's credit, that language of vulnerable adults is not used in the new revision of penal law. What's used in the new revision of penal law is those for whom the law foresees protection. So the category has been completely genericized. The only place it refers to is Vos Estis Lux Mundi, but since Vos Estis Lux Mundi is up for renewal, revision, permanent death, whatever, in this May, because it was approved for 3 years. So this May is the 3-year deadline. So it is my hope, even if not the best accurate reading of the tea leaves, it's my hope that it's that definition of vulnerability that's going to be reworked, and that in reworking it in the past 3 years, we've found a better way to get at these power dynamics, because that's for adult victims. Those who have cognitive deficiencies, I mean, to conceive of that form of abuse is grotesque. But if it's in the law, it's because it had been experienced and it needed to be responded to, period. So that's grotesque. The power dynamics, are they equally grotesque? No, but are they a serious issue that needs to be addressed by the law? Absolutely. But as lawyers, we have to find the best language to do it. It's easy to respond. It's easier to respond in the civil forum than in the criminal forum. The church doesn't have that option. We have to respond in criminal law in the church. So we have to craft a definition that can be applicable. So what are the characteristics of those kind of power dynamics that create a relationship? Is it someone who has office? And is it someone who reports to them because they have office? What language do we need to use? It's clear what the problem is. What's unclear in the church is the best language to use in a criminal proceeding within the church.
The civil justice system is really slow in reacting, and it takes decades and decades for the whole system to come around, because instead of having one legislator, we have the people who are represented by representatives at the state level, and then each individual state can change the law. It's going to take time, but unless it's taken care of, that's the next wave that's coming. And the law can change. Look-back windows can be created, and then law forward can also be changed. So it seems to me, as a student of history, that it tells me that if the institution doesn't take care of it, it will be taken care of for them.
And just one quick addition, I'm sorry. Everything I've spoken about is on the legislation on the universal level. The local bishop, the local religious superior, they also have legislative authority. So there is nothing prohibiting any bishop or any, head of a religious community from taking, Canon 223, which is about chaste celibacy, which in paragraph 3, it specifically foresees the possibility of local legislation. So the bishop would be able to issue his own legislation, and not only then, he would take on the responsibility for the application of the legislation. So not everything needs to be solved by Rome within the church. The church loves the principle of subsidiarity. We need our bishops to love it as much as the church claims that she loves it, and so that they can take some of the responsibility for this as well. It's not just the case that Rome does, because in the US, our system works slowly, but we have experience, and we have experience that is culturally sensitive. So why not have legislation that's crafted specifically for these cultural things? We have the essential norms. The bishops did this in 2004. Why? Because there was a gun to their head, clearly. So, but does that mean that they can't continue to move forward? No, but they have to want to do that. And they have to be creative enough to do it. So, sorry. Mary, please, bring us home.
Okay, so again, it gets pretty simple for me, based on what Father John Paul just said. If you know the people who come to you, you pay attention to them and what they're asking, you really get to know them, you can advocate for them. Irregardless of all this, people can be served and cared for. And we, those of us who do this work in the church, cannot use all of this as an excuse not to do that. And we have to use our voices on the behalf of those people who are vulnerable, who don't have a voice, I have victim survivors who have developmental delays. Their stories are horrible. There is nothing that precludes or excludes lay people who work in the church, for speaking for the victims and finding a way for them to speak for themselves.
Mary just said something about victims speaking for themselves, so I thought I'd pop up. Thank you. I just wanted to say the point about ecclesiology is really important, because when I came forward as a victim of adult, so I'm not even in the canon law. I don't exist. I checked the civil law and made sure, okay, this is assault. The civil law is kinder to me. I came forward wanting to be treated as family. And if there were time for us to, continue a discussion, I would ask a question about, like, how do you balance the legal with the fact that we are a family? And I wrote an article in which I said something about how I went from a sister to a legal liability as soon as I talked to the ecclesial authorities, even though I wasn't going to civil law. What I said to my friends is, these are my fucking pastors and they're treating me like lawyers would, which broke my heart. And the dynamic, you know, I love having the three of you sitting there together because I want there to be hope. I'm so glad for what the lawyers have done. I'm so glad that I could look that up and see that was sexual assault. And I was so pissed that I was being treated like an enemy in my family. Mary, your work gives me hope. And so I just wanna say that publicly here. Thank you.
Thanks, Emma. We're scheduled to reconvene at 1:30. I'll be in touch with the panelists, just explaining the time for the previous panel. I should just say there are clearly many more questions, and although we're going to have a concluding panel that was supposed to start at 3:15, it's designed to be a conversation that helps us bring some of the insights of the conference together. So I would encourage you to think about questions you might like to bring to that concluding discussion in addition to those that might arise from listening to those panelists. Okay, thanks everyone, and we'll see you in a little bit.